everyone, I'm Linda Loveland here with Jake Parker, General Counsel for the North Carolina Farm Bureau. Spoiler alert, we won. It all looks good. We're talking about the Fourth Circuit Court of Appeals, this ruling on farm labor. So looks good. You were very excited when you told me about this.
Yeah, the Fourth Circuit on yesterday issued a ruling that two provisions that were included in the 2017 Farm Act, these cases are starting to have some long years to them, that they are constitutional. And to briefly describe them, Farm Bureau has policy that opposes the unionization of farm workers. There are good reasons for that. Unionizing farms, strikes in agriculture are not a good thing for getting food out to people. And there's certainly, in our view, other ways to handle labor disputes on farms. But we were hearing concerns through our Farm Bureau policy process that farmers were being forced to check off union dues, that is, deduct the value of union dues from their employees' paychecks and send them to the union, which was putting the farmer in the position of being a treasurer for the union, essentially. We believe that the members can pay their own dues if they want to do that. And then the second provision dealt with settlement agreements that were requiring farmers to go into collective bargaining agreements, which is, we believe, it's very clearly not allowed under federal law, and each state gets to choose how they want to do that. Some states have collective bargaining for agriculture, some don't, like North Carolina, we're a right-to-work state. And so we were beginning to see this process of farmers getting sued, and then for all sorts of various claims about wage and hour issues or worker conditions, et cetera. And then through the process of negotiating them, there would be this love letter that was sent to farmers that said, hi, we can settle this if you would just agree to collective bargaining agreement, which we didn't think was proper. So our members developed this policy, and we went to the General Assembly and asked them to solve that problem. The General Assembly adopted those laws in 2017, and guess what happened? We have a lawsuit. Yes. We're getting used to that. So that lawsuit happened in 2017.
And so now, though, I mean, this ruling kind of surprised you.
Mm-hmm, it did. What happened was from 2017 till 2021, so almost 4 years, we were in federal district court going through the process of getting the case heard by that court, getting it all the way up to what we call summary judgment. And the court ruled that the checkoff provision, the part about union dues, was constitutional, but the settlement provision was not. And so you had a kind of a split decision from the district court. Both the Attorney General's office, which again has been a great partner in this case, and the union that sued against the law, they both filed cross appeals with the Fourth Circuit Court of Appeals in Richmond. So both issues were up before the court. And what the Fourth Circuit held was let me get them right, the checkoff provision was constitutional. So it agreed with the district court on that. But it said that the settlement provision was also constitutional. So it reversed the district court on that. So both provisions are constitutional, hence we win.
Excellent. So moving forward?
A little bit tricky as we move forward.
It always seems to be.
As we always have these conversations. The plaintiffs in this particular case can file for a rehearing with the same three judge panel. That's usually not very successful. They could also ask the whole Fourth Circuit of 15 judges to hear the case. Or they could, of course, file a petition with the United States Supreme Court. We'll know within a couple weeks which route they decide to go, if they decide to go with either one of them. But this is a really big win because those other options are not there's not a high likelihood of success for those options. So it was a really, really important ruling yesterday.
Okay. So with the holidays and all that, I'm assuming there's a deadline that they have to meet if they're going to
the middle of January is when they have to make a choice one way or another which route they want to go. They can stay in the Fourth Circuit or they can go to the U.S. Supreme Court at this point. And we'll know that, again, sometime in mid-January.
Okay. So in the meantime, though, we've had a couple of nice
We've got
nice
one more.
decisions.
We've got one more out there. About the Property Protection Act case. That one's been out for a year and a couple months. So I'm waiting. I think that one might be coming soon. So we might be doing this again in a couple days, hopefully with a win.
Yeah. Well, in the meantime, we'll take the win. So good job for you and your team. I know that takes a lot of work, and again, it's another example that policy matters, right?
Absolutely.
All right. Thanks, Jake.
Thanks, Linda.